Go. Okay, so we'll show that the motion passes. I've been elected interim chair for the purpose of this meeting. We found that there's a quorum. There's 3 board members present to conduct business. And our first business is approving the previous meeting minutes. And I'm seeing 2 meetings on here, but I think we had the minutes for 3 meetings. We had 10-1, we had 9/24, 10-1, and 10/29.
Correct.
Okay. On 10-1, I just had the third to last paragraph. There was a continuous instead of a continuance.
Okay.
And I was absent there, but it shows me motioning to adjourn. So it had to be John or Frank. I wasn't sure which one. So, and were there any other, for the other members, are there any other changes proposed to those minutes?
No.
Is there a motion to approve those 3, the minutes for 9/24, 10-1, and 10/29, subject to the changes that we just discussed?
I'll move that we accept the minutes as amended.
I'll second that.
So all in favor of motion to accept regular meeting minutes 9/24, 10-1, and 10/29? And I'll make clear that I'm not voting on the one that I wasn't present for, but I think
Good.
we have enough to approve all of them. So I'll show that we passed with all of us there. Next item on the agenda is for members of the public to reserve a time to speak on a specific item. And since we're on a Zoom call, it's important that when you speak up, you say just your full name and your address. And because we're going to write these down, and so we have them for later. So Amy, is there should people just chime in if they want to?
If you want to, sure. If you want to talk after, we go through the beginning of this, just raise your hand right now and I'll take your name down. And then after that, we'll let you in and then you can tell us your name and your address after that. So, yep, I have Sandy, Nancy, David. Benjamin will be able to talk at representing the applicant first. And
can I ask for a point of clarification?
sure.
Yes, go ahead, please.
Is this public comment period sort of my time to lay out my client's appeal and sort of the substantive grounds of that appeal? Or is the board contemplating that public comment would be taken now and I would be given an opportunity after that public comment to further discuss the appeal in detail?
It's a good question. It's just for the procedural item here is just to grab the names of people who wanted to speak on different items on the agenda. And then we take that list down, and then on an actual agenda item, applicant would speak first, or appellant would speak first, and then we'd let the public comment, and then you could have there'd be a rebuttal for those. So we're just lining folks up, but we've already got you in to go for your slot on the issue. So
okay. Yeah. Thank you.
Okay, we're all set on my end.
okay. So the one piece of new business we have on the agenda is the application for administrative appeal by South Berwick residents, Deborah Ganster and apologies in advance if I say your names incorrectly, Deborah Ganster and Joseph Dallatorre of 576 Emery's Bridge Road, South Berwick, Maine. They're here represented by attorney Benjamin Plant. And he submitted a letter with exhibits that we've we've taken into the record that's dated June 2nd, 2021. And it outlines basically objections to a planning board approval of the preliminary plan for this proposed subdivision. And that's MSP number 20-009, Providential Equity Development LLC, proposed 5-lot subdivision located off Bennett Lot Road, map 10, lot 71. Did I miss anything on that? I summarize, I guess the nature of the appeal is that whether or not the approval of a cluster style subdivision in that location is appropriate, to the extent the planning board has made that decision by deeming the application final. And the next item we have to reach is our own jurisdiction to hear this appeal. And so I wanted to just open, let's see. Usually we do this, the other board members, I'm open to input, but usually we kind of do this amongst ourselves. But since we have the benefit of having the appellant's counsel here, and we have our own code enforcement officer, I'm wondering if we can't hear anything substantive until we found jurisdiction, but I'm wondering, because jurisdiction has been raised as an issue here, if it would be helpful for us to hear from everyone on the issue of jurisdiction only, and then proceed from there. So does that sound like I mean, it's usually helpful for me at least to hear that from folks first. So Frank and Maya, is that something that
Sure.
sorry, can you hear Frank? Can you hear? I can't hear.
We can't hear Frank.
No, I can't hear what was talking.
Frank, you might have to speak into your laptop.
Yeah, I said I can't hear anybody talking. So,
That's you. Well, maybe you'll be fine, but I'm not fine.
Okay, can you hear us, Frank?
yeah, I can hear you, but somebody talking way in the back.
Oh, so. No, I mean,
Can everyone hear me?
Yes.
Yep.
Okay.
I think we have one person who needs to mute right now, Joan Conlon.
yes,
Can you mute so that Frank can hear?
Okay, she's muted. Frank, will you try again, please?
What do you want me to say?
Oh, so you can hear me?
Oh, yeah.
Okay. Okay, so we should be okay then.
Frank, can you hear me okay?
Yes, sir.
Okay, what I'm just proposing that we hear from everyone on the issue of jurisdiction only, and nothing on the substantive nature of the appeal. Is that something that you both would be open to?
It's acceptable.
Okay. I don't think we need a motion for that. I would just, I think the sequence we laid out was we'd hear from the appellant's counsel first, and then we'll hear from the code enforcement officer, and then I'm not sure if public comment is appropriate on the issue of jurisdiction, but if someone wanted to address it, I don't think I would object, but I think right now, let's see, in attorney plan, I'm not going to hide the ball and kind of what my concern is. The issues are, do we have jurisdiction to hear this appeal based on, essentially ripeness. Is this a final decision of the planning board that would actually be appealable? And then also, is it appealable to the zoning board of appeals rather than directly to the Superior Court? So is it an issue of this is not a chapter 140 issue. This is a chapter, this is a chapter 110. No, wait, that's not right.
121.
Yeah, right. So basically, you see what I'm getting at. So I think, I would hand the floor over to you on the issue of jurisdiction only, because we haven't found that we have it yet. So.
Okay, great. Thank you. Good evening, members of the board. So again, my name is Ben Plan, and I'm the attorney here representing Deborah Ganster and Joseph Delatour in connection with this appeal. And first off, on behalf of my clients, I'd like to thank everyone for being here tonight. One point of order that I did want to make prior to proceeding to my arguments, James, excuse me, Mr. Chairman, you mentioned that the only materials that you had were the application and the documents that were attached to that appeal application. And I would like to note that I submitted some additional documents from the planning board's record to Amy. And I just wanted to clarify whether or not board members had received those materials or not.
We did. We got the share file link with those additional materials, and if we get past the jurisdictional issue, we would go towards, we can accept what we can accept into the record, but those were received. So.
Okay, great. Thank you. At this time, Mr. Chairman, I'd like to ask that I be allowed to share my screen.
Yes, of course, but just also just keep in mind that we're only going to we can't address any substantive issues of the appeal right now.
Yeah. Just bear with me one moment here. So again, Ms. Ganster and Mr. Delatoro have requested that the Zoning Board of Appeals review a decision made by the town's planning board on May 5th to allow Providential Equity Development, LLC, to proceed to preliminary plan review of a 5-lot subdivision proposal using a cluster subdivision design. Ms. Ganster and Mr. Delatoro own property that directly abuts Providential's lot and have been actively involved in the planning board's review of Providential's proposed subdivision, both by submitting written materials to the board, including a letter objecting to the planning board's consideration of this project on the same grounds cited in the appeal that was submitted to the zoning board. And Ms. Ganster and Mr. Delatore have both presented in person to the planning board at its various virtual meetings. So the board's ordinance provides the board with broad jurisdiction to hear appeals from determinations of the planning board made in the administration of Chapter 140 of the town's ordinance. On May 5th, the planning board made a decision in the administration of Chapter 140, essentially to endorse Providential's cluster subdivision design and permit Providential to proceed to preliminary plan review utilizing a cluster design. So the zoning chapter of the town's ordinance itself contains provisions that relate to and govern cluster subdivisions. And moreover, the process for determining whether an applicant for subdivision approval may proceed to preliminary plan review utilizing a cluster subdivision design. So more specifically, what section 140.47 of the zoning ordinance or the zoning chapter requires is that a developer submit 2 sketch plans, one for a conventional subdivision design and one for a cluster subdivision design. And before proceeding on to preliminary plan review of either design, the zoning code requires the planning board to make a determination as to whether the preliminary plan for subdivision approval must be submitted using either a conventional or a cluster subdivision design. And sort of wrapped up in the consideration of these sketch plans are some provisions relating to the application materials that must be submitted with a cluster subdivision proposal, and some of the things that need to be demonstrated for a cluster subdivision proposal to be able to proceed to preliminary plan review. A little more specifically, what the zoning code requires is that the number of proposed lots in a cluster subdivision may not exceed the number of units or lots that could realistically be created in a standard subdivision. So in essence, what all this means and what all these provisions amount to is that the planning board has discretion to direct an applicant to develop land as either a conventional subdivision or a cluster subdivision. And the planning board is required to make that preliminary determination or that initial determination as to how the rest of the project will proceed prior to reviewing any preliminary plans or any preliminary plans submittals. In this case, Providential submitted sketch plans for both a 5-lot conventional subdivision and a 5-lot cluster subdivision initially back in September of last year. And the planning board has considered these sketch plans or considered these 2 sketch plans over the course of 9 meetings dating back to September of last year and until May 5th of this year. And on May 5th, the planning board voted by a vote of 3-2 to permit the developer to proceed to preliminary plan review utilizing this cluster design. What the meeting minutes from the May 5th meeting indicate is that the planning board's motion was made and voted on and intended to accomplish really 2 things. The first was to endorse the cluster subdivision design pursuant to section 140.47 of the zoning chapter. And the next was to find the cluster subdivision application complete. And wrapped up in that determination and implicit in that determination and vote is this determination that 5 lots could realistically be developed in a conventional subdivision. And so in essence, given the jurisdiction that's conferred upon the Zoning Board of Appeals in Chapter 140, the board does have a role at this juncture in considering whether the planning board has properly administered the cluster subdivision provisions of the zoning ordinance and more specifically the zoning chapter. The zoning board's jurisdiction allows it to consider and decide whether the planning board's determination as to the manner in which land will be developed and in which an application, which direction an application will proceed as either a conventional or cluster subdivision. The board has jurisdiction to determine whether that determination by the planning board was correct, given the substantive standards governing applications submitted for cluster developments. So as the board knows, its jurisdiction is derived from the precise language of the town's code. And Providential's attorney has submitted a letter to the board, essentially arguing that only final judgments of the planning board may be appealed. In essence, that this particular determination of the board on May 5th would not be ripe for review. And Providential's attorney has cited some case law in his letter that sort of governs generally the final judgment rule. However, that case law is clearly distinguishable from this appeal. The case law cited really governs final judgments of a planning board to Superior Court. However, it has no bearing on appeals from a planning board to a zoning board of appeals when the zoning board's ordinance provides the zoning board with jurisdiction to review a decision of the planning board that is rendered prior to a final determination as on the application as a whole, essentially. So in this instance, it's the appellant's position that the final judgment rule really has no application or bearing on this particular appeal because the zoning chapter that confers the board with jurisdiction to hear appeals allows the board to hear an appeal at this juncture when the planning board has made a determination pursuant to chapter 140 of the town's code.
Okay, I thank you, Attorney Plant. Was that it? And I'll reserve you some, if other folks chime in on this issue, you know, I'll allow you to request rebuttal time, but I think next we'd hear from the code enforcement officer on if the town has a position on the just jurisdiction only.
Yeah, this is Joe Russell, the code officer talking, and basically when I talked to the town attorney, he couldn't make tonight's meeting. And I had sent you a letter based on our conversation about jurisdiction, and he felt because it had been through the process, through the planning board, that it is under their jurisdiction under 121.6, and that any appeals from that point would go to Superior Court on an 80B decision.
Okay, thank you, Mr. Russell. And now we've lined up members of the public to speak, but I don't know if that's strictly, you know, is there anyone who, you know, wants to address this jurisdictional issue, which is pretty much a strictly legal issue as to whether or not the board has the authority to address this appeal at this point. So I don't want to cut anyone off, but I think hearing from the appellant and the town on this is going to be sufficient. But I'm just going to throw it out there. Is there any member of the public who's already signed up to speak? Did they want to address jurisdiction on jurisdiction of the board, that issue? Since I gave everyone else a chance, I'm gonna, yes, and you can raise your hand through Zoom if that's easier.
And Wood and David German have their hands up.
Actually, and I can put it to the board too. Is this something that, I mean, usually we just address it on our own anyways, but should we wait to get through jurisdiction two before
David Galbraith is the town hired a planner. He had looked about speaking.
Okay, if it's strictly on the jurisdictional issue, then let me know. I'll recognize him to address that issue. Go ahead whenever you're ready.
Yeah, Joe, I don't think I should give legal advice to the town. I believe that should come straight from the town's attorney.
Yeah, okay.
Okay.
I wasn't sure, what you had. Okay.
Yeah. If he's already written a letter to you
Yes.
that says it ought to go to Superior Court, then
Yep. All right.
I would agree with that. So.
Mr. Chairman,
Yes.
Ken Wood from Matter Engineering. Could I just say a few words on the jurisdiction?
Yes, Mr. Wood, as long as it's just on the jurisdictional issue.
Well, we did respond to the Zoning Board of Appeals. We had our attorney, Matt Howell from Clark and Howell, write a letter to the board on June 18th, 2021. I just wanted to make sure that the board had that letter and it was part of the record.
Yes, we do. So we will, I have that June 18, 2021 from Matt Howell. And I think we did reference it in our discussion. Attorney Plant referenced it as well. So I think that's, yeah, so that the appeal and the letter, they've been received by the board and those will be part of the record.
Okay, thank you very much, Mr. Chairman.
Was there someone else? Was there another hand? I see
David
it.
McDermott.
And Mr. McDermott, if you have a statement as it relates to jurisdiction, we'll hear it.
David, you need.
Yes, I'm sorry, I had to unmute myself. Yeah, I have a question on this jurisdictional issue. The planning board has been making decisions under 140 and on this proposal for months now. The public has had no input really into this except through correspondence that's not really discussed. When exactly, I mean, the applicant spends hundreds of hours with the planning board, or not hundreds, but many hours massaging this through. When is the public supposed to, under this jurisdictional issue, address this problem? You know, if the public can only make an appeal when it's a done deal, then what use is the zoning board of appeal? I don't understand why you don't have jurisdiction in this. It's a decision that the planning board made. The plaintiffs certainly have a right to appeal that. What's 121 say that we have to go to Superior Court? I don't understand why we can't appeal. The applicants certainly appeal decisions that the planning board makes through the zoning board of appeal. Is it the fact that it's the public making this complaint that's holding this up? That's my question.
And thank you. And I'll take the question kind of as an argument on the basis, and just as the point relates to the planning board. If this does, we have to find jurisdiction as a threshold, and then if it gets through that threshold, then that is the time where we would hear from the public on all the issues relating to the appeal. So the point's taken as to the different chapters and the public input in the process. So was there anyone else?
Yeah, Mr. Chairman, may I be allowed to address the code enforcement officer's comments?
Yes, Attorney, but I just wanted to see if we could get through, if we're done all together, then I'll let you just address everyone at once, if that's okay. If there was anything else raised that you'd like to address. Are we good?
Oh, Ken Wood would like to speak again, it looks like.
Okay, Mr. Wood, go ahead.
Maybe that was from before.
Probably from before.
Okay, great. I'm gonna turn it back over to Attorney Plant to address if there's any new issues that were raised by those, any of the prior speakers, then he can address those in the jurisdiction.
Thank you, Mr. Chairman. I'd only like to address the town attorney's comments as to the proper venue for this appeal. So the provisions within Chapter 121 govern appeals to Superior Court upon a final decision on a subdivision application from the planning board. Very clearly here, what the planning board was doing in the substance of its decision was the planning board's administration of Chapter 140. And the board has broad jurisdiction to hear and consider appeals from any determination of the planning board in its administration of Chapter 140. I think the issue's fairly clear cut. So I respectfully submit to the board that the proper venue for this appeal is before the Zoning Board of Appeals, and then would be to Superior Court depending upon this board's ultimate decision. Thank you.
Thank you, Attorney Plant. And now I think I'm going to close this to everyone else except the board, and so we can discuss the issue of jurisdiction, because it's more of a question here than I think we usually see where we can deal with it. It's pretty straightforward. So, and also, if any of the board members have follow-up questions for anyone who spoke, please go ahead. I think if you have follow-ups.
I have a question, James.
Okay.
Joe Roussel, I didn't see the letter from the town lawyer. I don't know if that was sent out, but can you please repeat the gist of what it said?
Yes, I proposed the question to him that they would discuss, they wanted to appeal the decision of the planning board under a preliminary decision. And when we discussed it, he said, I agree. He says, I agree with the conclusions below. Jurisdiction is a threshold issue, meaning the ZBA must decide whether the appellants have standing and if the appeal is properly before the board before reaching the substance of an appeal. Appeals from a planning board decision on a subdivision application must be taken to Superior Court pursuant to section 121(6) of the subdivision ordinance. I let Attorney Plant know I will not be attending the meeting tonight. And again, this is going through as a subdivision application. Yes, you have to go through zoning to make sure it meets the codes and stuff like that, but it's going through as a subdivision application. And that's why he said 121(6) applies to this decision that you guys made, and it goes to Superior Court under an 80B decision.
So is the town lawyer essentially saying that the zoning board of appeals does not have jurisdiction?
Correct. He's saying that's what he would be fighting in court.
Okay, thank you.
And I think, since he's not here, we have to just to kind of take that as part of the mix here, because I thought it was persuasive that, subdivision, has its specific chapter, but the clustering provision is part of 140. And I'm just going there. Hold on one second. Yeah, so 47 does say the planning board in making its determination whether or not clustering will be required shall consider this and that. So it literally says planning board is making a determination, and then our jurisdictional provision says we can hear appeals from determinations of the planning board. So it's so yes, the subdivision says you may appeal subdivision determinations to the Superior Court, but most a lot of subdivisions if they're not dealing with clustering, then they're not ever touching 140. And yes, those would be, but I think once they're making decisions under 140, at least we have the question of because it literally says they're making a determination, and that's under chapter 140. So is that a determination that's appealable? I think, I think that kind of, I was persuaded by that, at least. My concern is more about kind of, is that a final decision? Because really it's, what they're deciding is how this is going to be submitted for approval. And is that, is that something, that it may not proceed any further. It may get entirely changed. It may, there's a lot of things that can happen with these applications once they're deemed complete and submitted for approval. So, all they're really doing is finding, they're deciding whether it will be submitted for review as a cluster development. So it's being submitted for review as a cluster development, but will it be approved? But I think the Mr. McDermott's point is well taken. I mean, when are all these things considered? Did the planning board already consider everything that would go into the decision of this being a cluster, and now that decision's done and it's just going to go forward? Or is that going to be on the table as this moves forward while they review it? Oh wait, Maya, you're muted. If you.
Sorry, I was talking to someone else.
Okay. Yeah, I think there's a potential issue if these are sort of preliminary determinations of how something is going to be submitted for review, if those are appealable to the planning board and then appealable to the Superior Court from there, you could, subdivisions would go and linger out there before they're, before we even know if they're going to proceed in the planning board or if they're going to be approved. The final plan is going to be approved. So it is I think it's a tough case because it's hard to know, is this done for the, is the clustering decision just a done deal now that you couldn't appeal once it goes to final, or do we have to wait?
Is there anyone who could comment on what the process for the public input would be if the Zoning Board of Appeals decides that it does not have jurisdiction?
I guess, maybe we could open it back up to the code enforcement. We could also get, provide for rebuttal to see, for input on the actual kind of application process, what stage it's at, where it's going to go from here if it just continues, and is any input or question about the clustering, is that going to be on the table, or is that essentially final?
James, I would have Bill Straub, the planning chairman, discuss where the process is for the planning board at this point. That would give you a little bit of an insight on what you're trying to figure out right now.
Okay. I'm just gonna, it doesn't say a lot, but I'm just gonna pull up the procedure here. Yeah, so just looking at 120, 130, it says purpose of the preliminary subdivision plan process is to allow a detailed review and discussion of the proposed subdivision in order to provide guidance to the applicant prior to the submission of a final plan. And so it's kind of up until that, it's kind of a soft process where they're providing guidance and seeing how it's supposed to be submitted. And it seems like a lot of things could change or a lot of input could come in, but at that point, the the decision's already made as to whether it's going to be submitted as a cluster. Do the other board members have any points of clarification on the jurisdictional issues?
If Joe was suggesting we hear from Bill Straub to help with the decision at this point.
Yeah, I think we could hear from him if he was here. I don't think we can.
He's here.
Oh, he's here.
Hello.
Yeah, Bill is here. I can see him on my screen.
I can speak to the process. This is Bill Straub, Chairman of the Planning Board. I don't know that it has much to do with the jurisdictional question, however.
How about I do this? How about I ask Attorney Plant, would you have an objection to a discussion of the planning board process from here and how much and whether or not, you know, the structuring as a cluster would be further examined?
Mr. Chairman, I guess my objection sort of would be based upon the extent of any comments that the chairman of the planning board may offer to this board. From my perspective, it's fairly clear that this cluster subdivision design has been permitted to proceed to preliminary plan review. And I think the question really of whether or not 5 lots could realistically be created in a conventional subdivision has really already been decided by the planning board. And I mean, that's really the focus here is whether or not the planning board got it right with respect to whether or not this conventional design could have been permitted as proposed by Providential. And my understanding of the process, and I think all that this board really needs to know is that the cluster subdivision design that is proposed, that includes 5 lots, is what is moving forward. And I don't think that there's going to be any future consideration of the conventional design. So I guess to summarize, I don't generally object, but I think it depends upon the scope of the planning board chairman's comments.
I think maybe my tendency is would be not to get into it from here. So if this was an appeal, what would the standard, if this did proceed, you know, what standard will we use to review the planning board's decision on clustering?
My understanding is this would be a de novo appeal. My reading of the board's ordinance is that there is nothing specifying that that this is appellate review, and this would be a de novo hearing.
Is there a concern? Is there a concern that you would not have standing to appeal to Superior Court if on approval or you know, if yeah, if the final plan was approved, is that,
Well, the appellants are abutters to the proposed subdivision. They have submitted their objections in writing into the planning board's record. So certainly, I think they've demonstrated those two threshold requirements for standing, those being whether or not a property interest is affected by the proposed development and participation in the proceeding below. But nevertheless, you know, what the appellants are requesting now is that the zoning board look to this determination that was made and essentially send this process that the planning board has been following back to an earlier stage, and essentially back to a point where the planning board would be reconsidering the conventional design that was proposed and the viability of that conventional design.
and I'll kick it over to the other board members to chime in, but I guess the way I'm seeing it is that, you know, my concern is that this is a decision on whether a plan will be submitted for review in a certain way, and determining how you submit a plan for consideration by the planning board is, you know, there's still a lot that can happen, and it doesn't, you know, I do have the concern about finality, and I don't know if, you know, the case law was on point for exactly what it is, but it's just, I think the concern is jumping into appellate review at a stage where something is just deemed appropriate for submission for review, could just interfere with or go beyond the scope of what we're supposed to be doing as a Board of Appeals. So that's the proposition I'm gonna put over to Jill and Maya. Frank and Maya. If to see what you think on that, and then we can call a vote.
It would seem that upon preliminary review by the planning board, that an appeal could be filed at that point or beyond by the appellants if they believed an incorrect decision was made. So what I'm saying is, from what I'm hearing so far, it seems like there is an open door for an appeal of a planning board decision, even at the point at the preliminary plan review or after it. And I guess I'm wondering if I'm understanding that correctly.
I think that what makes it difficult is just that there's no really good rule on this. It's just, you know, if we accept that we can, you know, that it's an appeal under 140, you know, it's really more of just a general question of is it ripe for appeal? Has something been done that actually is so final that we can pass a judgment on it? And I'm leaning towards no, because I think it's just, you know, it's a threshold consideration about how a plan is submitted for review. But the review hasn't been complete. There will be more input under the process set out under the subdivision chapter, and And that's going to, yeah, that's where I'm leaning, but are you saying that opens the door to sort of, or to appeal of every, you know, you're concerned about opening the door to appeals of every decision?
I guess, like, from a layperson's perspective, it's, once the planning board has made a decision that has some finality to it, in my mind, that would be what would get appealed, and then the zoning board of appeals would hear that. And it seems to me, and I do feel we're missing a fair amount of documentation here. I didn't get my normal envelope, and I don't have the letter from the town lawyer. I didn't get to review several of these items. But it seems to me that we're in a non-final state, and that there would be further opportunities for input. It would be difficult for us to make a decision on something that hasn't been decided yet.
I think we ended up in the same place. I think yeah, that's a good way to put it, is that, yeah, essentially the concern is finality of the decision, whether, you know, they've done enough at their level for us to review here.
Mr. Chairman, may I be permitted to address the board once more?
Yes, and after that, we'll put it to a vote unless there's a new issue that we discuss based on that. So, but go ahead, please.
The way the board should be looking at this is essentially a final determination has been made by the planning board as to how this project is going to proceed, and furthermore, that 5 lots could realistically be developed within this conventional design. There's certainly no indication that any of that is going to be changed. The board will be solely reviewing, this cluster design from here on out, based upon a 5-lot proposal. Further consideration of the conventional design, the planning board has moved past that juncture. So in essence, the planning board has made a final determination as to the viability of the conventional design, and that 5 lots could realistically be developed within that conventional design. And that is the decision that we're asking the board to review tonight. Certainly the appellant's position isn't that, you know, for instance, waivers could be appealed to Superior Court at any given time in the planning board's proceedings. But this precise decision made under the zoning chapter is at least a final determination as to certain aspects of the proposal. Those aspects being whether the lots in the cluster subdivision could be realistically developed in a conventional design. And I would further add that the board's jurisdiction under its ordinance is what it is. It doesn't distinguish between interlocutory or final judgments. It simply permits the zoning board of appeals to hear determinations made by the planning board in administration of chapter 140. Perhaps I would agree with the board's position if the ordinance itself distinguished between final judgments and non-final judgments, but the ordinance does not. And therefore the board's jurisdiction is set by the precise terms of this provision. So with that, thank you.
Thank you, Attorney Plant. And I think we just, yeah, we've gone back and forth, and we probably ought to put it up to a vote. And I think, in terms of what, what information people want to have in, in the appeal, it's still, I think the finality is still going to be an issue because, we don't know, in the final plan, whether certain things will be changed to address concerns that might have been raised or addressed here in the appeal. So we might be, I do think we'd be getting ahead of ourselves to open up the substance of all these things without seeing what the final plan is and if it is or is not approved after going through that procedure. But I do see it as a close case. One thing I do note is that when we do take the appeals, it's looking if it's clearly contrary, if the decision is clearly contrary to the law, and it's a pretty, it's a hard standard to get through. But here I do think we'd be kind of, I think ripeness is kind of an inherent limitation on a judicial or quasi-judicial body, even if it's not expressed in this. And so I do have the concern that, we do need to, that ripeness and interference with another entity's function is going to be a big consideration here. So is there any other, do the board members have any other, inquiries that they want to make before we vote?
I do have another question. If there was an appeal filed at the preliminary review stage, and if the appeal was that rather than a cluster, a standard subdivision should be considered, could that appeal be heard at the preliminary review stage and potentially taken into account at that stage?
I mean, that's a good question. Is this a decision being made in every, would everything be appealable based on whether it proceeds on a clustered or non-clustered basis?
Because I
Is
think
that-
it's part of that finality point is, are we at a final decision, or is there still that opportunity to say, hey, we should be looking at not just a cluster format?
Mhm.
It speaks to that ripeness thing, I think. And I don't feel like I understand that yet.
Yeah, and I think it's yeah, then I guess, we can just go, it is kind of just a, we've got our ordinance that says, we can hear appeals from determinations of the code enforcement officer or planning board, the administration of this chapter. So, it's there are some legal limitations on that, but I think we'd have, it's a close one here. So, but I think maybe, I guess the vote would just, or if someone was to propose, move a vote.
I'd like to make a motion that what motion are you looking for? That we go to vote?
I guess we'd either have to move to find, move that we find that we have jurisdiction, or move that we find that we don't have jurisdiction to proceed on some basis.
So the motion would be a motion to vote on whether we have jurisdiction?
Right, yeah.
I would make that motion.
Okay, and are you moving? Is it a vote? Okay, is there a second?
I don't understand. the
I think the motion is to, motion as to whether or not we have jurisdiction to hear this appeal. So yes, we have jurisdiction. No, we don't have jurisdiction. So, or you could do it the opposite, you could phrase it the opposite way, but I think, the motion is to, yeah, I think we can do it either way. So what's on the table right now is a motion, a motion to find that we have jurisdiction to hear the appeal. Do we have a do you have a second, or should we rephrase the?
I have to disagree. I don't think we have.
Okay, I think then we can, so a no vote would, we wouldn't proceed to the next stage if we had majority no votes on this. It's just kind of, if we phrase it, that we move, so the motion is just phrased that we have jurisdiction, but if a no vote would mean that we don't. So if you disagree, you can vote no, or you could move to find that we don't, and then, see if Maya seconds that, and we could proceed, so.
So the motion then, you do have jurisdiction. That's
Right, I think that's what's on the table, right?
Can you repeat your understanding of the motion? Because I think all I was attempting to motion was that we vote. And I don't even know if you needed a motion for that.
Okay, but maybe, do you want to move, if someone made a motion as to kind of what, just worded either kind of positively or negatively, that, vote that we do have jurisdiction, or that we don't. I think that maybe that's what we would need.
Frank, do you want to have a go at a motion?
Yeah, I would move that we do not have to hear this case.
Okay, is there a second on that one?
Can you repeat the motion, James?
Oh, I think Frank moved for a finding that we make a finding that we do not have jurisdiction to proceed.
I would second that motion.
Okay, so all in favor of the motion that we do not have jurisdiction to proceed, you can just say aye, and then you can say your name, even though we know who you are. So
Aye, Frank.
Aye, Maya Bo.
I'm an aye, and so James Mundy, but and then I think in terms of a finding, I think, I would find that we do have jurisdiction under, chapter 140, because there was a determination that was made, but just that the determination is that the plan may be submitted for review, and that the review process would, is uncertain enough that we don't have an ability to review the determination at this time. So that was a bit wordy, but I think, to the extent of finding helps everyone proceed, is if there's a motion to accept that or rephrase it, maybe we can do that.
Do you need a motion at this point, James?
Yeah, I think if we want to do a finding, kind of a finding to explain that our vote, yeah, we can move to just make a finding that, you know, kind of just the basis for our decision, because there was kind of two issues that were raised, that the, you know, should this go to Superior Court and not us, or, and if it goes to us, should it, you know, is it right? So basically just that, you know, if we decide on the rightness alone, that's maybe just to just, we can just either adopt it kind of as I summarized it, or, you know, you can rephrase. So,
I would motion that we adopt the findings as you phrased them.
Frank, is there a second?
My second.
Okay, all in favor?
Aye. Maya Bow.
Bye, Frank.
No, aye, James Mundy. So, I think, you know, I'd like, that's much more in depth on jurisdiction than I think any of us have ever gone in one of these meetings, and I appreciate, you know, is it excellent advocacy on behalf of the appellant, and, you know, good input from the public. And, you know, as usual, it's not an easy decision. So we appreciate everyone being here. Is there any? But I think that's the last order of business. So I think we need a motion to adjourn. It's 7:41 p.m. So,
I'll make a motion to adjourn.
Second.
okay. And before we vote, Amy, did we miss anything you can think of?
No, you guys nailed it.
Okay, so we finished the agenda items. And I think we'll be producing in order based on this or decision that will go out shortly. And then, so I guess now we're going to vote on the motion to adjourn. So I'll start by voting aye, James Mundy.
Aye, Maya Bow.
Hi, Frank Gilson.
Okay, thank you. We're now adjourned.
Okay, thank you.
Thank you.
Thanks.